Hola, hola. Hola. Bueno, buenas tardes. Gracias a quienes ya están acá. En honor a la...
Thank you very much for those that are already here. In order to respect the agenda, we're going to continue with the first panel of the afternoon, the second to last one of the day, and second to last one of this one, which is our workshop on transactions involving IP. How do antitrust authorities evaluate them? We have Maria Rosa FABARA that after this video will give you a short introduction about the panel. Transactions that involve IP. How do antitrust authorities evaluate them? Mauricio Velandia, advisor lawyer of FALCONI PUIG Lawyers, Colombia. Carlos ESGUERRA, founding partner of BERMÚDEZ and ESGUERRA, Colombia. Moderator, Maria Jose Fara, managing partner of BUSTAMANTE FABARA, Ecuador. Good afternoon, everybody. I want to thank you, particularly for those that are already here present with us, for having come back in a punctual manner to this talk that I am absolutely confident will be extremely interesting for everybody, and that apart from this, it will be very useful for each and every one of you to get to know what recommendations our experts with regards to competency have in order to be able to carry out the practices that we carry out on our day-to-day work in IP, and also the interrelationship that exists with trust law. Trust law is not recently, but over plenty of years, has been closely related to the issues related to intellectual property. And the topics have been analyzed not only from an outlook of what everybody got to know, which is intellectual property itself, but after the panel, you would be able to conclude what I am telling you right now. I am confident that they need to be assessed according from a different outlook. And what is this outlook? The outlook of economic competitions. And our experts today during the afternoon will be providing us green lights about how to carry this out, what are the most important topics that have to be discussed, not only the ones that are related to transactions involving intellectual property, but also how antitrust authorities evaluate them. And in addition to this, how to focus our practices to be able to provide an appropriate counsel to our customers related to this topic. And with no further ado, since you came to here to our panel members, I'm going to introduce the first one of them that's going to discuss this afternoon, and his name is Mauricio Velandia. Mauricio, please. I would like to thank you very much for that introduction, and thank you very much to ASIPI for your invitation to be able to talk to you about some topics that are extremely current, not only with regards to our Latin American area, but also towards a European tendency and a North American tendency, and with Chinese tendencies, because it is, let us not forget that China is the second world power that is also operating here. So we're going to discuss various issues that are related to economic integrations. The first issue is that when we talk about fusions or economic integration or a concentration of entrepreneurial markets, the first thing, it's important to verify the field where this will happen or take place. And currently now there are non-traditional fields that little by little are causing it so that intellectual property can be able to operate within transactions. Currently, it's not useful to be able to purchase a company. Generally, you purchase a brand. Generally, nowadays, you purchase intellectual property in an extent. Currently, not only do we have operations which report greater tax consequences, but what we try to do is try to find these type of operations that are of high novelty. And this is done in some specific fields. I'm talking about the field of the metaverse, where there's going to be huge amount of movement with regards to this. Because as you are fully aware, the kind of metaverses that exist are infinite in their possibilities, and in very few years we will be able to see how metaverse fuses with the intellectual property of each metaverse, and how it's going to be able to have a merger, which is called an intercommunication of metaverses. And it's important for us to be able to keep this in mind. Another important point will be artificial intelligence, and everything that is related to all of this concept of AI. particularly with regards to chips, which we will discuss in a couple minutes, as a new asset that you should consider in acquisitions. And this is something that is being presented between China and the United States. And there's this discussion, and Taiwan is the main producer of chips around the globe. And everything that Taiwan implies in the geopolitical situation of the world with regards to what a chip can as part of a component and as intellectual property and industrial secrets. Another market which will be opened will be something that's very futuristic, which is the space market. And basically the four richest men are investing in the space market, and when rich people invest, it's because it's going to move forward. We can keep on having a very traditional market like brands or anything that can happen in a market that we have conceived and gotten to know for approximate 30, 40, or 50 years. And patents, as you know, they began in the 1700s in the United States. And in China, in 1985, it was when the first patent were existed. Nowadays, the people that want to have more protection for their patents are Chinese entrepreneurs, because they're seeing that they are going out of their market and they realize that they do not have a protection because they were not used to a protectionist market. And I'm going to highlight China a lot in my talk because China is a huge investor in our region, more so that Ecuador has signed a free trade agreement with China. And this means that the opportunity is endless with regards to all of the investment that is coming forward. And this has to do with economic integrations. And all acquisition operations which are happening are coming from people that effectively have this related to this. And I come back to space trade, because when we realize that over on the globe, they're investing a lot in space, which is an investment that perhaps we cannot even see it because we're so far away from it. I have always thinking that thinking small has small consequences and small thoughts. And if you have a big goal or you're thinking big, you're going to get good, big things. Because if you, those people that have conversations with lazy people will stay lazy, and those people that are thinking future market, which is intellectual property, have to start thinking that there will be certain purchases on behalf of some people, because the inputs on some markets are huge novelties, and the space market is somebody that has Jeff Bezos involved, that has China involved with all of their part, and Europe is also more relegated, and Russia is also included in this, without taking into account that Elon Musk, to a certain extent, has this part very well elaborated, and there are certain integrations with all of the robotics and genetics that he has, which is pure IP. So what I'm trying to transmit in my first intervention is letting you know that there's an absolutely new market with regards to IP, where the Latin world and the Ibero-American world cannot be lagging behind, and they cannot just simply copy what is happening in Europe or in the United States. We have the full possibility for growth and the full possibility to show and express ourselves, but we need the criteria and the sufficient security to be able to move forward and not wait for people to tell us through foreign universities or foreign books what we need to do. Within this, it is also very important to talk about the quantum market, which is another market that's opening up, and there's a lot of mergers that are happening at the worldwide level. As you may be fully aware, the quantum market is part of quantum physics. The last five physics Nobel Prize winners are quantum physicists. So the future markets, such as distribution channel, will be quantum markets, to put it into words. So I think that the evolution and the developments that are happening is a new field where the economic integrations will be very, very important. Even though we might think that we are not attractive for these companies, because we have a lot of inputs in order to make ourselves attractive. And I'm going to stop on the topic of chips, because I think that this topic is the one that can take into account a couple of things regarding to integration and how they're moving. Chips are those small components that to a certain extent you are seeing that are present in everything. Smartphones, internet, and things have their own chips. And the integrations that are being presented throughout the globe are between the companies that use chips that come from Taiwan, South Korea, United States, China, that are always included in this. There are certain Latin countries like Brazil and Mexico that have certain companies that are involved here. But the chips as sort are that source where data is being able to kept, and the microprocessors are also a chip. And issues related to IP, and where all of these companies will try through robotics and artificial intelligence to be able to find integration, because we're a very important market for them. And to a certain extent, they will try to find this protection. So I invite you, apart from any type of integration that we're going to see and how we can elaborate, is to be able to be fully understand that there's a new novelty market that is related to development. And development are based on the space market, which is coming soon, within 15 years, quantum market, which is 5 years away from the quantum computer, and the chip market that if you read The Economist or The Independent or the New York Times, you will be able to see that the commercial warfare is for chips and IP that is included there, plus ChatGPT that is generating music through a couple of creations that already existed. We will have a wide array of vertical integrations that are understood. That is, somebody has an input. If somebody has the product available that is going to be joined to that input, it's very important. And it's also worthwhile mentioning that all of the trust authorities will have a huge task in order to determine whether there is copyright issues and if whether copyright issues are being bought. And every integration has research and development in mind. Currently, we're talking about killer integration. What is a killer integration? A killer integration is basically when a producer buys another smaller competitor, and they kill him within the market because they do not want to have any competition, and it kills all of the IP belonging for that company. So within brands, within patents, there is a huge work of IP lawyers that have to do, and certain trust authorities that have to determine the new markets, their own developments, and also verify whether monopolies are being created within those markets. The issue that is arising now, related to robotics and related to artificial intelligence, is an issue that is being discussed right now. If people have a dominating position over our dimension, and if whether the robot is creating has copyright issues. And why is this question? Because the creation of a machine needs to determine who owns that machine, and if what is created by the robot, to a certain extent, will be the property of the owner of that robot or to whom they belong. So here I just want to take into account this. There are 5 new markets that when they have intellectual property, and it's very important within those new markets. And apart from this, Chinese people are going to come here because they're the second world power. And I think that this is very important for us to take into account, more so for Ecuador, because they have an FTA with China. But apart from this, there's also an issue related to acquisitions and mergers, and the trust authorities need to be prepared because they do not know about this, and they're going to be very complex within their existence. And obviously, they're going to generate a lot of work for intellectual property lawyers. And we are undergoing a business when, if you are not up to date with what's happening in the world, then you are a person that is lagging behind in a different era. You can decide whether you are lagging behind, or if you are part of the old market and now you are up to date with everything. So our invitation is for us to be up to date. We have to be part of the new era, and we cannot be our older selves with regards to our legal and intellectual property issues. Thank you very much, Mauricio. What is very clear from your presentation is that antitrust authorities, and particularly those in the jurisdictions where there is a control for concentration or monopoly activities, are checking the intellectual property issues within any type of transaction that is considered as concentration activities. And Carlos ESGUERRA is going to comment a little bit, or a lot more, about this. So please, Carlos. No, thank you very much. Can everybody hear me fine? Thank you very much to ASIPI. Thank you very much, Maria Rosa, for your presentation, for Marco, for the invitation. That was very pending for me to be able to arrive here, and to every person that came in this very difficult time. I want to use my 10 minutes, and please let me know how much my time is doing, to be able to add some highlights about the entrepreneurial integrations that have an IP component to them. And my first question that I have to ask myself as a lawyer, as an authority, whether it's an IP authority or a trust authority, what is a merger? What's an integration at an entrepreneurial level? Strictly speaking, or very simply speaking, it is very difficult to be able to define what is the concentration of an entrepreneurial integration. The easiest way to explain is what is the minimum thing that an entrepreneurial concentration is. The minimum thing of a concentration, according to the theory that is presented by the Latin American authorities and worldwide authorities, is that the acquisition of an asset to which you can associate a business participation and sales to it. If we are ever to send this into the IP, what would be the most precarious operation and the most inoffensive operation that might be a concentration of entrepreneurial powers? In my opinion, this would be a brand license or simply an IP license. There's a very important case, Yahoo and Microsoft, where the only thing that they had with the transaction, the only thing that they implied was giving a license. And it wasn't a permanent license, it was a license that was for 5 or 10 year period. And this was considered to be concentration at a company level. There was no shift of an asset as such. The license itself was a concentration, and perhaps this was the first call in the what ASIPI asked me of the messages that I wanted to share here, and that's why it is important for us to be able to take into account trust since the very beginning, because something as inoffensive or as far away as what one would traditionally think that would have a concentration, such as a brand license or an intangible asset license, can be configured this. In Colombia, we have a couple of older cases of certain travel agencies where there was only the use of a license of a software plus the handling of the software where all of the sales were going to happen, and this was considered and it was sanctioned by the competition authority as a non-informed integration, and then they decided to check certain 20 integrations in that specific market. So once we define this, when is it notifiable in front of the antitrust authorities for the entrepreneurial concentration? The regulations will obviously change according to jurisdiction. There are certain jurisdictions that you have certain thresholds, and if you go past those thresholds, which is a very important discussion to have, of assets or revenue, those thresholds that would trigger compulsory notification in almost no cases, or maybe in no case, are the amount or that the asset is worth, or the brand is worth, or that the intangible asset that you are trading. But the assets of both companies added up. What does this mean? It thinks that they are thresholds that are very easy to trigger, with the exception of El Salvador, where the thresholds are so high that having a percentage of the GDP, but that's a very exceptional case. Generally speaking, these thresholds are very simple to be able to go past. They're like tens of millions of dollars, which for important transactions are very, very easy to overcome. Therefore, it is very easy for a transaction that involves intellectual property can thought to be a company concentration that is subject to prior notification. And I think that here we reach what is the problem, or what is the difficulty. The big difficulty that we have for these cases, the difficulty that we have is that the rights and the industrial and intellectual property rights try to seek the same thing as competition laws, is for markets to become dynamic, that entrepreneurs will be able to invest, risk their investments, and generate innovation. Nevertheless, they try to reach that objective from two very different points. Competition and analysis tools. For competition wants for there to be a lot of competitors, and for the final prices for competitors are very low. On the other hand, the IP law rights try to find the objective towards innovation from a point of view that is completely opposite to this one. In other words, they grant you an exclusive right over a specific market or over part of a market, and this obviously is an absolute detriment of the number of competitors that exist. And this has an effect over prices because the sole competitor in a market or in a macro sector can charge prices that are over what would happen if there was direct competition. Nevertheless, this is a price that is given to innovation. It is an incentive so that companies can keep on investing, keep on innovating, and keep on creating. So what am I hitting to this? The main objective or the main problem that we have is that you are granting a transaction to officers from the antitrust authorities so that they can review it. Those officers have two specific characteristics that are very difficult and that we do need to take into account when we design our own strategies. First of all, they almost never, these officers know about IP. They just do not have the knowledge about it. Even in Colombia's case, which is an antitrust authority that also has a delegation for IP, they do not have that level of expertise available to them. And second of all, which is even more serious, because they could learn in theory, and some of them might know, but even more seriously, is that the tools that are compulsorily tools that need to be used by those officers that check these operations are excessively focused on two specific factors. First of all, the number of competitors, and second of all, in the final price for consumers. So therefore, in certain transactions or markets that have a strong mediation based on IP right, the diagnosis that is carried out by the competition or antitrust authority is very biased and generally does not work correctly because you are able to find very few competitors or perhaps a sole competitor because they have a patent or perhaps they have a design, an industrial design, or for any reason they're the only competitors. And you see that that person, obviously, is going to recover their investment using prices that the standard for analysis for the competition authority is higher to what they desire for there to be. Therefore, they have certain indexes. They have the HHI index and the pressure price index, and generally this is not going to work correctly in these cases. It's going to be excessively biased, and this does not mean that the market is going to work incorrectly because of the transaction. It means that the officers from the antitrust authorities have their brain configured to only check one part of the story. And here is where we require to have a very positive team for competition lawyers together with the IP lawyers that hopefully will arrive prior to the discussion and that they are able to explain the competition officer and say, listen, this is what we're going to have. We understand that you're going to find or that your analyses will provide or yield these results. But I have a counter analysis where we have taken into account the incentive for innovation, which is something that you should also protect, that is going to counteract these effects. If you do not reach this analysis previously, you are in a huge risk for the transaction to be objected or subject to certain remedies. And one last issue with regards to what I wanted to say is that that partnership between the IP lawyer and the competition lawyer needs to take into account something, which is the elephant in the room that almost nobody is talking about, but that's very important, which is the political context. Each authority and each country has their own political context, which is different. Right now, Marisol goes to the metaverso. The discussion that we have with entrepreneurial integration of IP is focused primarily on the transaction between Microsoft and Activision. Because there is a fear, or some authorities fear, that perhaps this could generate dominance over the market in the metaverse. The interesting thing about this topic from the political point of view is that that transaction, which is exactly the same one with the same problems, was already authorized by the European Union, that generally is the most stringent authority in Brazil, South Africa, in Serbia, in Chile, in South Korea, in China, in Japan. It was blocked in England, which almost has the transaction towards a point of failure, and it would be litigated in the United States by the Federal Commission. Why is the same transaction generating these diverse decisions? Particularly in the case of England or the UK, where perhaps the United States market might be a little bit different to them. According to my reading or my take on this, is that this is a political ideological posture. In the United States, we are going from a new change or shift in paradigm with regards to competition with a current that's called the antitrust hipsters, which have a negative attitude towards platforms, and what they try to do is separate the platforms and separate big conglomerates. So that political context is the one that's causing for this to block the transaction in the US. Meanwhile, in the UK, after Brexit, the big interest that English or UK authorities have is to be able to have a different posture than the European Union and send a message and say, listen, I'm different to the European Union, I'm not like them. And I think that that's the main reason why after these analyses, this is moving from 1.8 to point B. In Latin America, of course, we need to be very careful with our political context, particularly with something that's more earthly than the metaverse, which is seen by those brands that have a level of love in the country. For example, the main coffee brand, the main chocolate brand, the main brand for beer, for whatever. So this generates a couple of tension, and it generates an interest on behalf of the officers to say, okay, here I want to have a say over this. And this is something that needs to be identified. And once you identify it, you need to identify it early. Thank you very much for that, Carlos. I think that the question, upon hearing our panel members say this, I think that our colleagues should be asked this question. So in all of the transactions, including in the minimum standard that we have discussed with regards to licensing, has at some point in time you been worried of determining whether that transfer of domain or whether that licensing or franchising can be considered to be a concentration operation in the eyes of the antitrust authorities in that country? And if it is the case, if it goes over those thresholds, then I think that now, upon hearing to Mauricio and to Carlos, particularly after the questions that I'm going to be asking them, I think that you will be able to agree with me that we have a big pending task to do. And we have plenty of work to do in order to be able to approach this. So Mauricio, why do you think it is important to be able to take into account intellectual property rights as an asset in order to be able to notify an economic concentration operation? What is your thoughts on this? I think that lawyers of commercial law or trade law generally buy their trade law book and they read it. But the person who wrote that trade law book is not somebody that does trade. The person who wrote the book is not in trade, therefore the book cannot have things that happen in trade itself. Because if not, he would be an entrepreneur, and how is he writing commercial law if he does not have anything to do? It's a criticism for us, and it's also criticism for me as individually. What does this mean? This means that it's very important to read marketing books that allow us to understand what market positioning means and what market penetration also means, which are stages that an entrepreneur knows very well how they do, and that an IP lawyer that works with brands and commercial names should also know that if there is a specific operation or a legal business where a lawyer goes in order to be able to determine what things need to be done, which is different to trade, but it is the obligations that appear within any contract, is that the lawyer at least should understand that a brand generates a distinction, and the distinction at the end of the day would generate market penetration or market positioning. When a lawyer understands what market penetration positioning are, is when they will understand when an integration operation was being discussed in the market, and what the antitrust authority is going to check is how much concentration there is in market penetration with regards to the product that that brand, that license or patent have. And obviously, if there's not only positioning or penetration, because there's very well positioned brands that do not have penetration. For example, Hitachi. Hitachi is very well known amongst us, more from people from my generation. There's younger people that perhaps don't remember what Hitachi is. I don't even remember. Or BlackBerry, for example. BlackBerry is a brand that has fantastic positioning, but penetration, they have none. And precisely is because somebody has a fantastic brand, and what they do here is they're not in the modern world, which is different. They're in the contemporary world, but not in the modern world. And in the contemporary world is where things are happening, that we have all of the digital natives that are very different to the way that we operate, that they're very different to digital immigrants, and they have different markets and positioning because they come from an area of video games where the world is heading. And that's why it's important to have an integration, or why, from the point of view of intellectual property, it's important to have this. And I would say that it's important because of the following things. During an integration, we have penetration and positioning in play within the market, and this is only provided by a brand. That's why in all of the magazines, there's a most important brand and which one is the one that are going to buy. And an investor does not care about this, nor the manufacturing behind this. They can do it in 2 minutes. That's why when we have an entrepreneurial integration process, one of the items is how useful it is to have a new company for entrance barrier. And the important thing is the brand, the patent, the invention, the research and development, because it is there where we would have a problem with integration. And even during the distribution channels, which is something that's also related to penetration and brand penetration itself. So you do not have to forget that to a certain extent, what is being discussed during a concentration operation is how much it will be concentrated in the market with specific brands. Or from the point of view at a vertical level, if there's an input that is required by that main brand, and they purchased the input, and that input might be a patent, this input might be a license, as you mentioned previously, or franchisees. But what catches my attention is why it's important to have an integration from the intellectual property right. And that's because brand is distinction. And brand name is a distinction. And this means positioning and penetration. So my call for you is, if at any point in time you have some type of legal business that involves a brand, try to find a competition lawyer. I don't think that it's completely necessary, because the issue related to competition is only Wiseman that does this, and I don't believe this is the case. I think that it's a simple issue related to penetration, positioning, and logically market participation or market share, which is something that you will need to be able to discuss with regards to intellectual property that is involved. In other words, what you're selling, what you're acquiring, what type of market participation that has, and at the moment when you present this, obviously to open up that relevant market and say, I'm not going to be a monopoly, nor will I be a dominant position, because the bad thing about mergers, independently whether they are from IP or from any case, is that our customer wants to be paid for the operation. The notification to the antitrust notification is the least thing. You need to open up the market and say, here there's a world of substitutes, a different world of patents of brands, so there's no imposition for somebody to invent if they wanted to. That's what I believe. Fantastic. Carlos, how would the antitrust authorities analyze a concentration operation which involves intellectual property rights? Thank you very much for that question. I'm going to take 2 questions to 2 minutes to complement what Mauricio says. Mauricio says that the big problem is that the operation is at a standstill, and I completely agree with him. But I think that that's the second biggest problem, because the most serious problem is that you do not realize that you needed to go to that antitrust authority, because you did not realize that it was an concentration. Not only would it be a standstill, they're going to ask for you to de-invest in that, and obviously you will be sanctioned, plus any type of reputational risk, which would be the only complement that I would have to add to what Mauricio said. So it's complementary to your question. Your question is complementary to what I had already been saying. A recommendation for authorities and also a recommendation to lawyers so that they are able to generate that dialogue. I think that the focus on the promotion of innovation and on the promotion of innovation should be the main element that authorities, antitrust authorities, need to understand at the moment when they're carrying out a transaction which involves intellectual property rights. Nevertheless, for this reason, the competition lawyers should have a partnership with intellectual property lawyers. We need to carry out important work. And this important work that needs to be done is to be able to achieve for that a different analysis standard is being understood by the markets that are IP intensive, that there is an analysis standard that is recognized in the specific guidelines and also in the minimum requisites. Because what is happening and what we need to understand from antitrust authorities is that antitrust authorities have their hands tied. For them, it is very costly and risky to be able to deviate for the international standards, and particularly from the standards that they imposed in the guidelines. Therefore, in the cases where we do have guidelines and the countries that do not have guidelines, they follow the guidelines from other countries, they're going to say, I'm going to base myself on this. They're going to base on concentration, the number of competitors. We know that there's no problem. The effect on price, and almost nothing else. So those guidelines need to be updated with full knowledge of the things that are coming forth. And coming back to the case, or the en vogue case related to Activision and Microsoft, is precisely related to this. The authorities that understood that by generating those type of monopolies and understanding that those monopolies, above all in markets with high level of invention and innovation, are temporary and they're very fragile. So they were able to understand that with certain remedies implemented, that transaction would generate positive effects for the market. On the contrary, the authorities that are almost the most sophisticated ones that check the number of competitors and prices ended up objecting to it. So I think that beyond thinking about the way in which things should be assessed by an authority, we need to check to see how an authority wants to assess we want our authorities to assess our transaction. That's why we need to be very mindful of what are the effects of that checking over that transaction. And I think that it's always much better to be able to have an open, candid, and transparent conversation with the authorities than trying to cover the uncoverables and say that here we have certain effects. We know what you're going to identify. I can give you the work already. Here are the effects that you're going to check. Here's going to the way that you are able to counteract them. And if necessary, you will be able to start once and for all with a negotiation of possible remedies that will be able to be useful for you. And for that, I think that it is very important that the lawyer or the competition advisor is involved since the beginning of the process, starting from the valuation itself of the assets and also during the due diligence, to understand two things, which is complementary to what Mauricio said. They need to understand the companies, first of all, and second of all, they need to understand the transaction. And this way, they understand what's hurting that entrepreneur and what does not hurt that businessman. And for example, what type of brands that might have a fantastic positioning, we may not include them because they do not have the penetration that I have. And this is something that I can offer to the competition authority. Hopefully here we do not have somebody from BlackBerry present, but in a hypothetical case where Mauricio was explaining about an integration or a transaction between the BlackBerry brand and perhaps a better positioned brand like Samsung or Apple, I think that one of the good strategies at the beginning is that if you know that we have these conditioning, they're saying I'm going to offer BlackBerry as a brand. Perfect.
What has been the position of the authorities, antitrust authorities, in terms of IP rights? Could you please tell us something about it? Well, my education within this issue started when I was in charge of the division that handled this topic in Colombia, which makes somehow, but we have, if we understand at the responsibility level, maybe we can find what we call the legal of the topic. We have to understand this because for a lawyer, if they understand very well the subject matter, the scheme of responsibility is to have the cause. But we have a damage, but it has been well advised, and then we have a scheme of responsibility. So this is in the law, and we have these certain damages that happen, but we have to understand if there is an intentional damage. But to understand the competence within economics, we have to understand what is the good or the asset that is advised, because I can change this legal aspect. Because if we're talking about IP, we don't even know what the subject matter or the asset that is in the competency. So what we're trying to protect here is that the consumer somehow is protected. The consumer, in terms of consumer, the prices should not go up, and all the income that they get that will allow them to purchase more things. And this is not through competency, because this is the competition, because this is going to lower the price. If a loyal business person likes competition, no, of course not. They want to have their own business right there and to earn more money. So from the IP standpoint, what do we find on a day-to-day basis? What we have as an economic integration, in order to make a function of companies, we try to finish with the competition, because if I merge with another company, there is less offer. And this is a process of entrepreneurial or business integration. I'm taking away this offer in the market, and I'm concentrating my offer in the market. So an entity as an authority, and according to the experience that I had about 20 years ago in an antitrust authority, of course, that there are no barriers to the entry. That means that there are enough brands within the market that somehow there should be no barriers to enter all the foreign investors somehow. So that's why I said that the most important thing within an business integration to study the positioning and penetration of the market. There would be other types of circumstances because at IP level we understand that there are a series of components different from the brand or the trademark, such as the business secrecy that may occur. But insofar as an antitrust authority finds that any person can enter the market regardless of selling brand, secret, patent, whatever, the operation, of course, has to be sanctioned because whatever is interested in the integration, this is a very important concept. And what I want to say in addition that there are many tools for integration to happen, and also the interpretation part is very important. And nowadays we talk about the national champions. The United States have that. They have Google, Facebook, Amazon. Why? Because their economy depends on them as well as their economic power. So have we seen many sanctions against Google, Facebook, or Amazon? Not only in the European Union, but we are all delayed. We have delayed it to get there, and of course they don't get into them. So I think that to be concrete with the question, the antitrust authority must have a request by you that will allow the authority to be calm, that there is not going to be a dominant position as such with regard to the operator that is going to remain. The dominant position is done with competition and not with a wallet. Although the market is wallet, but the dominant position is acquired because the clients choose that person. I would be happy if I would be the commercial VP of a company and say that I have a dominant position. That means that I am the best and they have chosen me because I'm the best. But there is a great fear that lawyers involved in the brain of a company to say that they cannot have a dominant position to have it. I would like to invite a company that has a dominant position, and if you want my advice, I will give it to them. But the first thing is that in their advertising say that they have a dominant position because the public have chosen them. So the integration of a brand, we don't have to fear about that because in the context somehow the brands can have a very important emphasis. There are a few remedies nowadays that are being put forward within the market. The first one is to sell the brand, and that's the easiest part. But selling the brand, that's very important for your business and mine. If there's an integration and we have a brand selling, there are many snakes that want that brand, and there's an opportunity, a business opportunity for those who purchase the brand when they say who's integrated to sell the brand because they are going to purchase it very cheap because the other party is in conflict and the economy is not really good. So when there is an integration and this is objective, there must be a purchaser that can purchase it, and they are going to purchase it very cheap. It's not only the lawyer within the operation, but all the other people who have the knowledge that there is an integration. And I would like to wrap up with this. Don't think that the integration is two people making an operation. Integration involves all the competitors because they can participate as third parties who are interested and they can object at the operation. Since we're talking about competition, this is very hard and very complex. The companies, among them, that they tried to find a way on how to win the other, and the way is by opposing the economic integration. And we need an IP lawyer because they understand the barriers, how the patents, license, all these work. So the idea is not to present the integration, but to participate as a third party, asking for the objection of the operation. And you are the one with the knowledge, and you have this advice, asset that you understand the antitrust law. Thank you, Mauricio. What is the importance of a due diligence of IP rights before submitting or before concreting an operation of concentration? Well, I think that this is a very important question, of course, the due diligence from the rights of the competition standpoint. Well, I have had great experience in several processes in the entrepreneurial integration where it happens something what Mauricio said. These went into litigation. There were many, many competitors, and we had the two positions who were advising the competitors, and they wanted to stop the operation, or they wanted the remedy to access to an asset to a price that they were not going to access through remedies. And that brought about a series of concerns. In those cases, what happens is that the concentration or the business integration ends up becoming a forum of discussion, of which is the behavior of the companies in the market. And this becomes a scenario where a lot of sins are revealed. So, which are the sins that a company may have with regard to their rights of IP in terms of competition? Well, there are many. Their exclusiveness scheme can create a problem. Their their denial to hire third parties, that can create a problem. The scheme of licenses, that can create another problem. If they have a consortium of patents with others, that can create another problem. So there are many, many problems that may arise and become material as contingencies of future research or investigation. In those cases where we anticipate that there is going to be a very important scrutiny by the authority or an opposition by some actors of the market, I think that a due diligence of antitrust is extremely important, not only to be able to structure the sales and create contingencies and etc., but above all, to understand how are they going to tag, what information can be asked or requested by the authorities. And that's a moment where we reveal a lot of risks that perhaps you don't understand that you have, and that your competitors who want to stop that operation are going to be able to exploit that, and you are going to receive by the authority in some occasionally a requirement of information with very difficult questions to answer. And I think that with a prior due diligence is going to help you prepare in order to answer or to respond, not only to defend your business concentration, but above all to understand what other challenges may be ahead because of the media and the legal process that these brings about. Mauricio, you mentioned something about remedies, but I would like for you to talk a little bit about this topic, because I think that for the audience it is important to understand which are the remedies that you have seen in antitrust authority in the IP has imposed when approving concentration operation, or even as a result of an abuse of market power. Well, I am a professor. I am not a politician. I don't believe in politicians. I have never voted. So I think that, well, I'm going to try to tell this from the independent standpoint. From the antitrust law, this started in China. They amended the law, and Europe and the United States, they have their own laws that they protect the smaller company rather than the large companies, because the anti-monopoly is called, otherwise it would be pro-monopoly, but we defend the monopolies because that's my work, but my work is mostly academic and not from the political standpoint. I believe that nowadays China is a reference of the remedies that they have implemented in the latest operations when they have agreements of hardware, software, or any type of license among or between two companies that somehow they buy from each other. China is proposing to ban the mergers of those companies. For instance, if there is a purchase of a technology, That's okay. Okay, you cannot merge, so that then we allow. Then you cannot merge because we're not going to allow monopoly. Another remedy that I have seen here, if you see years back, there are many examples that are quite traditional from the distribution channels. We're talking about the traditional market and great services. Now we have the model market, and in matter of antitrust, we have the traditional competition from 1903 up to present, or the at least 10 years ago, the contemporary competition started. This is the condition and operation. This is by ordering the company not to raise the prices in the next 2 or 3 years. That's very hard because that means you remain with the price that you have now. You cannot raise it. And these are hard conditions. But there is another one which is to break exclusiveness clauses, because you know that in monopoly market there is exclusiveness clause. Otherwise, why is the monopoly right there? So who's going to input? For instance, if I have an IP right that somehow requires other input, or who's a seller and that is vertically integrated, is toward also to be able to sell the competitors that same product. The auditorium is now full, but I wanted to wrap up here because of time constraints. Before finishing here, I would like to say something that I said initially. And this is my today's function. There is a market which is the metaverse market, where there is an intercommunication of metaverse, and the IP issue is going to be very difficult because if we register from metaverse, well, there's going to be a lot of them. I think that you should look at the Shiran, which is the Asian metaverse, and you should look into it. I also recommend about the space market, where they are the four wealthiest men on the earth are investing. Also quantum physics, the four last Nobel Prizes have been in quantum physics, and this is going to be around the quantum physics. So everything that you see, for instance, the pen makers, they are also in the quantum the quantum issues, isn't a quantum issue. Well, tell us a little bit about the remedies. Well, I was actually waiting until this time to to agree with Mauricio. But I think that before ending, now I agree with him. I don't think that China is the reference right now and it's the most advanced in this. I think it's quite the opposite. I think that there's been a counter reaction to the Chinese authority, which is extremely important. But I believe that the direct influence of the world is concentrated in Europe, and the Latin American authorities review Europe. And in Europe, we see a few important advances of some remedies that are quite sophisticated. So the practical note of all this is that if the authority detects some kind of problem, it is very difficult to block it. Europe released a study of the last 97 decisions that involve new technologies. Out of those 97, 6 were objected, one because of the failure to comply with some law, but the other 5 was because of the market. The other ones were conditioned. And the interesting part of the conditions is that it implies that the investment, in my opinion, that is a victory that I would aim at the lawyers of those companies who understood very quickly and were able to promote what was the type of remedy that they wanted. For instance, in the case of Lilly, in Prozac, what the authority was told was, okay, look, do not obligate the investment because I need this income. Instead, I will commit to the mandatory license, but I need royalties. So that mandatory license, in another interesting case of GSK with Pfizer, what they did is, okay, look, I'm going to sell a few assets to a third party, and I'm going to license free of charge that brand for 3 years. while that company develops and position their own market and then their own brand, and they give it back to me afterwards. So these are very sophisticated remedies, and these are proposed by lawyers of antitrust and IP who understood very well this business and who understood the concerns of the authority, and they were able to promote very efficiently a few remedies that do not enter with the viability and the rationale of the business. And I think that that's why we should see the European market in order to understand and find remedies that we can propose, and which are the remedies that we should decide in the absence of a sophisticated proposal of remedies. And if there is a remedy, usually the authority is going to get the easy way. And Latin America is going to say, look, the invest and you sell it. Well, all the lawyers of IP are aware that even in the APEX and in our legislations, national legislations, we must have, and we have through international agreements, regulations that establishes that the mandatory licenses for economic concentrations of remedies and the investments, and I concur with you, are the most common ones that we have seen in the statements of the antitrust authorities. Well, we have no more time, but I would like to invite you that for the next time that we are involved in a few operations that imply or entail transfer, licensing, or any other transaction related to IP, we know that we have to do a joint analysis with the experts in the subject matter, or to become that, so that our clients can be sure about these issues. I know that I have a few questions. I have Luis raising his hand, and if the organizers can provide us with just 5 more minutes for the questions. Thank you, Martin. And then I will conclude afterwards. Well, perhaps you're going to say I'm sneaky and that I talk a lot, but I am like a parrot. I would like to contribute with a real case of an IP case in Peru. Recently, the antitrust authority analyzed the merge in the pharmaceutical market, in the pharmaceutical industry, and the team that advised one of the parties didn't carry out an accurate analysis that was associated to a generic, and this was well positioned in the Peruvian market. But they went to the phase two, and phase two is when there is a prior analysis, and if there is no problem, or if there's any convenience, it goes to phase two. That was actually the debate. How much was the brand worth? What impact it could have in the market? That the consequence was, I approve the merger, but you have to get rid of such and such brand. What was that? Was the main one. This was the result. There was no accurate and adequate advice to value that issue. Secondly, there is also constantly covered that was mentioned before. This is the most complicated process, because the target or the company that was purchased, they will never know that they are going to be bought, because it is even in the stock exchange. If you want to buy it, and the merge has a very important value in regard to an intangible like the brand, in this case, how am I going to value the brand in order to understand whether this is going to happen or not? I don't know, Carlos, if you can add to this. And now that Carlos is going to add his comments, I'm going to may put some hot sauce here. Well, somehow the assets of IP, they're not even counted, let alone that they are valued. Yeah, we have several aspects here. The antitrust authorities that are slightly sophisticated, and there are many in Latin America, in Peru, for instance, they have an authority with a very sophisticated level. Within their standard of analysis, they have a procedure and some exceptions for the hostile control tests. The procedure remains short because what these procedures seek is the confidentiality of the process rather than what you do to make the transaction if you don't have the information, and you will never have it. Of course, without revealing data that I am not able to reveal, but at some point what happened is that the authority, and I think this was very interesting, and this was even proposed by us, requested from another entity, and they said, okay, I request an investigation of a confidential proceeding. I want you to give me this information that the hostile purchaser didn't have. And the company delivered the information. But one thing is when you deliver the information with your counterpart, because in this case we're not going to fight what's happening. Okay, we are going to agree upon the same process, and we are going to say what are we going to say, how are we going to say it, and then they deliver the information without knowing that this is leading to a business concentration. And when information is delivered like this, then the messages can come wrong. And in this case, it was not possible to get the authorization because information came in a very difficult way. And also there was another difficulty, and this is that the authority receives the information, and once they have received it, I don't know, look, I don't know if I can show you. I mean, it means, okay, I have it, I'm going to decide your request with this, but you cannot see it. So we say, well, okay, please, okay, if you're not going to let me see it, then let the lawyers see. And of course, there was a signature of a commitment of confidentiality. This is what happened. So if there is a requirement of information which is quite strange, you have to review that, your shareholders. Okay, 30 seconds on the answer. I think that there is, that has not been discussed much about the accounting of these assets. When you are going to negotiate the remedy, and you want to tell the authority, look, this brand, no, because it is essential because of these 1, 2, 3 reasons. And they're going to say, yes, this is important because you have not counted. So how do you test the importance of the brand when it is not counted? And this is something difficult to handle. And this could also have a positive side of the play. If that brand is so important, perhaps they can be approved under the analysis, but it is not reflected in accounting. And I think that is a real difficulty. I would like to add something about what has been commented. I think that most of us are lawyers here, fortunately, and that has a context of rational, a rational way of thinking. Otherwise, the law wouldn't have been here. The competition is under a public order, and this is above everything. Now, public order cannot give away because a company does not want to make a hostile purchase. That means that the private, in particular, law is above that public order, and the constitutional court can understand that, but the antitrust authorities believe that they are wise and that they have created a new law, but that's not true. They think that they can create a law, which it can be a special law, but that they forget about this branch, which is the constitutional. So this is of public order, and in that way, if there is a hostile purchase, there's a creation of the greater risk at the responsibility level, and this has been consequent with the consequence that happened. So I do not agree that everything else is above the public order. Thank you so much for all your interventions. Marco Antonio Palacios, thank you so much for helping us to prepare this panel, and to you all for being in such a very difficult hour in a significant number. It has been an honor to be with Carlos and Mauricio, and thank you very much once again. Good afternoon.